Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agent will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Now, please dial the phone numbers that are displayed on the screen to talk to the attorney, Ms. Prashanthi Reddy now. Hello, Prashanthi. Welcome to the show.
Hello. Thanks for having me.
How are you doing today?
I'm good, thanks.
Could you please provide information on your law offices, practice areas, and your experience?
Law offices of Prashanthi Reddy. My name is Prashanthi Reddy. My offices are in New York, Manhattan, and I practice immigration law. And if you need to reach me, you can go to my website, www.reddyesq.com, or you can email me, prashanthi@reddyesq.com.
Today's topic, knowledge session on H-1B and RFPs Part 2. Before getting onto the topic, do we have any immigration updates?
I think we can discuss updates after we finish the general topic. Then if there's additional time, then we'll go with updates.
Sure. What are the changes to the Buy American, Hire American order by President Trump, which is now cut into half, becoming just Buy American by Biden?
So in general, we know that the Biden administration is much more friendly towards immigration, and Democrats have been in the recent past. When compared to the Trump administration, there have been a lot of news articles also as to how the Trump administration was trying to pretty much not just asylum and family-based immigration, but was completely trying to end H-1Bs and tried as hard as possible to end H-1Bs, starting right from that memo that you mentioned, Buy American memo. Starting from that, many regulations and executive orders and memorandums were seen as a result of that executive order. To start off with, there was the right to control regulation, which was there even previously, but just became more rigid. Basically, the situation is that if you were a consulting company and that if you were hiring employees out to other companies, and if the employees were working at a third-party site, then there was this tremendous amount of paperwork that had to be submitted and documentation that had to be submitted, and you had to show that you had worked for that person for the entire duration of the H1. Even though projects usually last for 6 months, 2 years, 1 year, you had to show for the entire 3 years period that you are asking for the H1 that you have a PO, which is not the way the consulting business works. So they were trying to end that consulting business model as well. And they also had become much more stringent with specialty occupation. And they came up with this new thing called specific specialty, where they said that if the job requires a bachelor's degree in more than one kind of field, then it's not a specialty occupation. Because, in order to be a specialty occupation and to qualify for a H1, you have to have a job in a specific specialty, which means just one specialty, or a group of specialties which are closely related. So, for example, they were saying that systems analyst position, which have been used in the past, and thousands of applications have been approved. They started denying systems analyst positions because they said that in order to according to the Occupational Outlook Handbook, which is a publication of the Department of Labor, which is what the book that they usually refer to, it said that a bachelor's degree in computer science or engineering or math is required. So it gave a wide array of subjects that could qualify the person to do the job. And they said that because it doesn't say specifically just computer science, it's not a specific specialty. So it's not a specialty occupation, and therefore they were denying the H1. So that was the other thing that they did, specialty occupation RFPs. and also making it harder for students by, whenever you file a change of status from F to H, they were saying that they were asking for every single detail uh, of how the student, whether the student maintained their student status, whether they maintained CPT status, whether they maintained OPT status. And also they came up with a new interpretation of saying that, if the student was on OPT and used up their OPT, then if they joined another program at the same level, for example, if they were doing a master's and they used up all their OPT and then they joined another master's, they wouldn't qualify for CPT. This is a new interpretation that they were giving based, on that memorandum. Pretty much everything is based on that. So then recently, just before the Trump administration had to give up power, they came up with a flurry of regulations. And, they were, some were struck down by courts, and then they reintroduced those regulations by, making amends to them. So, so they did the whole DOL wage thing. They increased the wages by almost double in October. But luckily, the court struck it down because they didn't give enough notice period. For a regulation, you have to have proper notice and comment period, which means that it has to go through a certain process. They didn't follow that process, so the courts pretty much struck it down. Same thing happened with, DOL memo, which was issued, which basically said that consulting companies, if a consulting company is going to place an employee at an end client site, then not only does the consulting company have to file the H1, but also the end client has to file the LCA and the H1. So there was a DOL memo which was issued based on a regulation that USCIS was going to publish, but luckily they ran out of time. So, so many things happened. And then, of course, you have the Trump executive orders banning travel into the US.
Okay.
Yeah.
We have a caller online, Mr. Raju.
Hello, Madam Prashanthi Reddy.
Hi, Raju.
Am I audible? Yeah,
yes,
I'm
I can
based in
hear you.
Bangalore. I've been watching these shows and, very, very articulated updates you give. But unfortunately, one area that was not covered was business visas. So I'm not sure if I'm allowed to ask, but I just quickly wanted to know, with all these new immigration changes that are happening, with the new government in place, is there any impact on the business visas especially for Indians?
So yeah, with reference to business visas, the impact is that you right now, because the consulates are closed simply because they're closed because of COVID. It's difficult to get a business visa.
So yes,
logistically
so it was
speaking.
closed till about 6 months back, but now they have just started giving, and I've got my slot sometime in the next 2 weeks. So I was just worried, is there any new laws or any impact that I need to be aware of?
Right. There's been no change, which is a good thing sometimes, because all the change that we've seen recently is not good change, but bad change. So there's been no change with reference to the eligibility for a B1 or a B2 visa. It remains the same. You have to show that you have no intent to immigrate, because they don't allow dual intent on the B visa.
Right.
And of course, you have to show ties to the US. And
ma'am,
you have to show
sorry
what
to
business
interrupt you, because I'm sure other callers are waiting and I don't want to take much time. But just one last question. Earlier and all, in about 10 years back, when we used to get a business visa for 1 or 2 weeks, and then there was a possibility when the employer or the people that we are visiting, they file an extension locally in the US and we used to get extended. Would that continue even now? Let's say we get stamped for about 2 weeks. Extension of business visas will still be available, or any advice from your side on that?
So nothing has changed on that also. In fact, a lot of people, because of COVID and they couldn't travel, there's been a splurge of extensions of B2s and B1s, and now you can even file it online. So they've made it easier to file. So regulations haven't changed. You can stay for a maximum period of 1 year with increments of 6 months on a B visa. So you can, after you come here, you can always file for an extension of up to 6 months at a time.
Okay. Yeah. Thank you, Raju. We have other caller, Rohit from Texas. So let's take this call. Hi, Rohit.
Hello. Hi.
Hi. Go ahead
Hello.
with your question.
Hey, I just want to check with Prashanthi about the Dropbox on the Dropbox. So I heard there is no appointment. I mean, I guess the Dropbox are open. So is there any specific reason, or is the Dropbox open for only emergency cases, or it's open for everyone?
The Dropbox is open for everyone. That hasn't changed. And as long as they don't see that they have a reason to interview you personally, then you can get it via Dropbox. The requirements for Dropbox is not changed.
Okay, one thing related to the Dropbox. If the employer is changed, I guess that still qualifies with the Dropbox, right? If both the H1 and the H4 both.
So if you previously had a visa, it's called visa revalidation, right? So as long as you previously had a visa and you're revalidating it, no matter what the situation is, you still can apply for a Dropbox.
Yeah. I mean, Dropbox, because the employer has been changed. Earlier it was employer A, now it's employer B. So my question is, even both the principal, like the H1B and the dependent H4, both are eligible for Dropbox, right?
That's correct, because they go together. But they can always, that is discretionary. Remember, the Dropbox is always discretionary. So they can always, ask you to come in person, even if you're eligible for Dropbox.
Okay.
Yeah, thank you, Rohit. We have another caller, Ravi from Iowa. Hi, Ravi.
Hi.
Hi, go ahead with your question.
Thank you. So actually, my question is like, can a H1B holder work 2 jobs in this COVID time? Because I heard that what I meant is, let us say we have changed a client and filed an LCA, and then I got another job, and I just filed an LCA for that. And can I work both jobs working from home? Or how should I do amendment in this case if I take 2 jobs?
So it depends. If you're for example, working for a consulting company and you're doing both the jobs under that same employer, right? You have 2 different projects. If that's the case, then you can just add both the projects to your LCA if the work locations are different. If the work location is same, you really don't have to do anything specific. You can file and you can, as usual, and show the employer worksite or your home as your work location and file it. And then you can take up additional projects. Nothing's stopping you from doing that. You don't need an amendment for that. But if it's 2 different employers, so say you're filing a H1 through ABC company, and then you have another offer of a job from XYZ, then you can file a concurrent H1. And a concurrent H1 that's what exactly it is. It's an additional H1 in addition to the H1 that you actually have. So the filing process is the same. It's just that we mark a separate column which says that it's a H1 concurrent. And the hours have to make sense, whatever you're putting in. If you're saying 2 full-time jobs of 40 hours and 40 hours, then the 80 hours, I guess, still makes sense. But if it's more than that, it may not make sense. So you'll have to do 1 full-time and 1 part-time maybe.
Okay.
Thank you, Ravi. Now back to our questions. So what does H1B RFE mean? So
RFE is just a short form for request for further evidence. When you file any petition with USCIS, be it a B2 extension like we were discussing earlier, or you file an L1 or a H1, whatever it might be, family-based petition, there could be a request for further evidence from USCIS before they grant you the certain benefit that they're going to grant you. And then when you send the document, usually there's there is a document sent, and they will give you a time period to respond to it. And if you don't respond within that time, then the case will automatically get denied. And if you respond and you submit all the documentation they're requesting, then they will grant you the benefit. If they're not satisfied with the documentation that you're submitting, then they could send you another RFE. But most probably they won't. Most probably they'll just deny it. It's rare that they send two RFEs on the same case. So that's the process for the RFE.
Okay. What is the probability that any random H1B petition will be selected for an RFE?
Sometimes you can predict that this case will be RFE'd for sure because you can identify the issues, right? So some cases are just waiting to be RFE'd. Like if you file a petition for, say, a restaurant manager or some position that where you know you'll have to justify that it's a specialty occupation because it's not clear. It's not clearly a specialty occupation. For example, if you do a lawyer, it's clear that a bachelor's degree in law is required and a license is required. You do a doctor, you know that there are no issues. But there's some positions where it's not clear that actually a bachelor's degree is required. For example, if you do a H1 for a computer programmer, USCIS for sure, that's a red flag. Some positions are just red flags: marketing, research analyst, computer programmer, systems analyst. Just because based on the way USCIS has been interpreting those cases, you know that you will get an RFE. So in those cases, you can say there's a very high probability of an RFE, maybe 80%, 70% probability. Or if you have not on status and you don't have an I-94 and you're filing without that, you know you'll get an RFE. So in some instances, the probability can even be 100%. But if the case is good, and in general, as a lawyer, you don't see any issues with the case, it can still be RFE. And the probability of that really depends on which administration, how USCIS is looking at cases. Under the Trump administration, 50% of the cases were RFE'd. Just every case was, 50% was RFE'd. And out of that, 50% were denied. So there was a huge surge in RFEs. But in general, if there are no issues, there shouldn't be an RFE. And I think it's gotten back to that level now, simply because of the constant fight, companies and attorney organizations, and they have been litigating against the Trump administration, and they have won some vital cases. And because of that, the RFEs have really gone down because they're not able to RFE on that basis. The courts have said you cannot, so they can't go against the court. So we have forcefully bottomed down the RFE level, not because of USCIS but because of the court system. Okay. So now we see the RFE rate is, if it's a provable case, is pretty low.
Yeah. What is the probability that the H1B petition will be approved if selected for an RFE?
So again, I answered that question, right? So I said that under the Trump administration, 50% of the cases were denied, the cases that were RFE'd. But now it's, I think, fairer in the sense that they look at each case. They don't go with a presumption or some kind of a bias against, certain consulting companies or certain types of H1s, certain nationalities. It really depends on the type of case. So if there are red flags in that case because they're clearly not approvable, then even if you respond to the RFE, unless you're able to show that the case is approvable under the law, the case is going to get denied. So it really depends on a case-by-case basis right now, which is how it should be.
Yeah. And the RFE, how long to respond, 2 months or 3 months, what would be the response?
So it's usually 80 days, I believe, or 85 days to respond to an RFE. And because of COVID, they have automatically extended the RFE response period and added 60 days to that. So from the end date, you can add 60 days, whether it be a motion, an RFE, a notice of intent to revoke, notice of intent to deny, whatever it might be. You can add 60 days to it and respond. So that has been very, very useful for us and companies and individuals because they have been delayed in getting documents. For example, change of status from F1 to H1, the universities are closed and a lot of documents are required from the university. So there is a delay to get that document. So that 60 days grace period has really helped, I think, the community, respond during this COVID time. That was one of the best things that is one of the good things that USCIS has done, I think.
Yeah. Can the beneficiary, the sponsored employer, respond directly to an RFP, or is the cooperation of the petitioner, the employer, is essential?
So H1B is a petitioner-based case. It's not a beneficiary-based case. So the beneficiary is not filing the case. It is the company or the petitioner that's filing the case. So a beneficiary, unfortunately, has no say. Is not a party in this transaction, so they cannot respond. Only the petitioner can respond, and if they decide not to, then even though it's the beneficiary that's affected and might go out of status, unfortunately, that's how it is.
Okay. So is it a luck to be issued an RFP? If yes, why?
So as I said earlier about RFPs, that some of them are random, but some you can predict. So as an attorney also, we try to file, since any attorney who has experience doing this, we can predict. And that's why we file certain documents we think are essential when we're filing a H1 in order to avoid an RFE. And those documents are, if you're again in the IT space, your basic documents like that, whichever space you're in, degree copies, you have to show that the person qualifies. So how do you show? You have to show that he has a degree that is related to the position. So if you don't submit a degree, you know there's going to be an RFE. So there's no luck there. Or if you're working, especially in the IT sector, you have to show that a job is available, that you're not filing a frivolous petition. In order to show a job is available, either you have to show what kind of business you're in. You have to show what kind of job the person is going to do. You have to document that. If he's working for a client side, you have to show the PO, the purchase order. If you don't have that, if you don't submit it, you know there's going to be an RFE. So there's no luck involved there. But sometimes you submit all the documents and still you get an RFE. That's where luck is involved. So sometimes that happens as well. Those are just random RFEs where, I guess USCIS has some kind of a quota that they're trying to fulfill and they randomly select some cases for an RFE. That's possible.
So with good documentation, there will be a decrease of the risk of RFE.
Absolutely, absolutely. So that's why we never file skeleton petitions, and we often fight with our clients to make sure initial petition itself is well documented. Because what happens is when you get an RFE for one issue, they will send 10 different issues in that same RFE, which they otherwise it wouldn't have come to their notice. So now instead of having one issue, they have 10 issues. And then so the chance of denial skyrockets once you get an RFE. So best strategy is to avoid an RFE by submitting all the documentation that's needed.
Okay. So if someone have been in H1B status for many years and never received an RFE, when time to extend status, either through the same employer or a different employer, will that person inoculated from receiving an RFE?
So previously, they used to give deference if it was a H1B extension. They always gave deference to that extension. And they would say that, if it's an extension, then you should only be sending RFEs if you see something that has changed in the previous petition. But with the Trump administration come in again, that's a change. That's another change. With this Buy America, Be America rule memo that he issued, one of the results was that was a memorandum which was issued by USCIS that even in extensions, they should not take it for granted. They should look into the merits of the case once again, even though they were looked into previously. So they asked officers, adjudicating officers, to look into the issues, revisit the issues, basically, which was not done previously. They never used to. So we often now don't see a difference between extension versus a new H1. It's the same chance of getting an RFE. Previously, in an extension, the only RFE that they could send was just to make sure that they previously were in status. So if they were in a H1 for 3 years, they could send an RFE saying, show us that you were in status for the last 3 years. show us your pay stubs, W-2s, etc., etc. That was the only type of RFEs that we used to get. Now, even if the job hasn't changed, again, they ask for specialty occupation. Again, they're looking into the merits of it. They're looking into the job duties, whether the person qualifies or not, whether the job exists or not. They're looking into all these issues which they have already looked into. So that is the difference, I think, between previously and now.
Yeah. So reasons of why an RFE is issued and what are the heightened scrutiny and resultant RFEs for H1B in financial year 2021. I think we pretty much discussed
Right.
on this.
Right.
Yeah.
So the only part, the last part, which is, I think, what are the issues with the RFEs in 2021? There are issues because there's some new laws, which, maybe we can discuss next episode. But there's some new laws that we need to look out for, and that might result in new RFEs. So right now, we don't have to worry about the right to control RFE. We don't have that anymore. We don't have to worry if the person is getting a wage level of level 1. Before there used to be RFEs on that. We don't have to worry about that anymore. Specialty occupation is something that we still need to worry about. So if you file a systems analyst, for example, there's some red flagged positions. If you file those, for sure, you're going to get a specialty occupation RFE in 2021 also. There is some change. If there is some change with reference to wage levels, and people start, because of that, people start using private wage surveys. So basically, there is a bill that has been published. There is a regulation that has been published, and the DOL wages have gone up by 50%. And it's going to start in June. So if that happens, then people will start using private wage surveys. So you can expect that there'll be a kickback from USCIS with reference to private wage surveys, and you can expect RFEs on that front for this 2021 cap season.
So what to do if we get a specialty occupation RFE? Right.
So if you get a specialty occupation RFE, you have to document that according to the industry, you have to show that in in the same industry, other jobs, they all require most of the time, not always, but at least if you show that more often than not, they require a bachelor's degree in a specific field. And you can show that by job postings. You can go to DICE, you can go to Monster. I'm talking about IT positions because it's just that a lot of H1s are filed for IT positions. You can get a letter from other companies saying that they always hire people with a bachelor's degree, say in computer science for this particular position. You can get an expert opinion letter from a professor in computer science saying that, this job usually requires a bachelor's in computer science. There are many things actually that can be done to show that it's common in the industry. You can take printouts from the internet, again, from newspapers, from ads basically showing that it's commonplace that companies always require a bachelor's in computer science. So, basically you have to show it's common in the industry. Another thing you can do is show that even if whether it's common or not in the industry, the job is so complex that, a bachelor's degree is required. So you have to then explain the complexities of the job, why it's different from other jobs, why a bachelor's degree is required in this job. So that's another way of showing it. And then, of course, you have to show that the person actually has a computer science degree. So you might have to get an evaluation of the degree to show that it is from an accredited, university, if it's a foreign degree. So these are some of the things that we can do to respond to specialty occupation RFEs.
Okay. We have a caller online, Raju from Bangalore. Hi, Raju. Yeah, I think call got disconnected. Let's continue with the questions. I think we discussed what are the reasons for the wage level RFE. Yeah, I think it got covered. And also currently there is a news on USCIS extends flexibility for responding to requests until March 31st, 2021. Can you help us understand the background?
Right. So we discussed that actually. So as I said, there's that 80 or 85 days
Yeah, plus
that
30.
anyway. Right. Plus you have the 60 days to respond. So that 60 days is the additional time given due to COVID reasons to respond to any kind of RFE or motion to reopen or notice of intent to revoke, or whatever it might be.
What is maintenance of status RFE?
So when you file a change of status from an F1 to a H1, say, let's take that example first. When you file a change of status from an F1 to a H1, first of all, one of the criteria is that you should be in status in order on the date of filing the H1 in order for the H1 to get approved. So that is one of the criteria. And so they will send an RFE wanting to make sure that you have maintained your status. So if you are on an F1 previously and you're changing to a H1 now, they can ask several questions. One is if you're on an OPT, they can ask questions on whether you met the requirements of your OPT, your optional practical training. Optional practical training, you're supposed to be at least volunteering. You can work for free, but at least there has to be some work. So they will make sure they will ask for a letter from the employer wherever you worked. If you worked paid, then you can provide pay stubs and W-2s. If you volunteered, then you have to show that you can get a letter from the employer saying that you volunteered or interned at their office. And also the work has to be it has to be related to your job. So you can't work in a gas station if you're an IT professional. That will not you will not meet the requirement then, and you'll violate your status. So that's, for example, if you're an OPT, that's what they're looking for. Similarly, if you're in a CPT, they want to make sure that you receive the CPT through valid grounds, meaning what's happening is a lot of students, because they are not getting picked in the H1B cap the first time, second time, and they don't want to leave the country, they keep doing courses. So they'll go from one master's to another master's, and they'll take CPT because they want to continue their employment, and the STEM OPT is only for, even if you're a STEM person, if you qualify, it's for 3 years, but still it gets over at some point, right? So if they want to continue extending their job and they didn't get their cap picked or whatever the problem is, they take CPT immediately upon joining the organization. It's called day one CPT. Or even if you don't take CPT day one, but you take it 3 months later, whatever the reason might be, whenever you take it, whatever the timing might be, they'll send an RFE asking for whether you maintain your CPT or not. First thing is whether you're eligible for CPT. So they'll ask you to show that the CPT that you took was an integral and essential part of the course that you were taking. So if you're doing a master's in computer science, you have to show that the job was an integral and essential to your course. You can show that by showing how the job was related to the subjects that you were taking. You can tabulate it, do it in a tabular form and show these are the jobs, this is the course that I was taking, this is how it is related. Also a letter from the university or a brochure from the university showing stating that it was an integral and essential part, and that the coursework is such that it cannot be learned unless there's a practical training aspect to the course. So that's how you show that CPT was required. Also, one of the RFEs that we were getting on CPTs with the new administration, as I mentioned, was that they said that if you took OPT 1 year and the OPT period is completed, you use the maximum OPT period that you qualified for, and then you did another master's level, meaning you didn't go to a higher level. If you went to a higher level, such as a PhD, you get an additional OPT period, right? But if you do another master's, what they're saying now is the law establishes that you cannot get another OPT period. But now they're extending that law to include CPT as well. And they're saying that you cannot get an additional CPT period also. They're extending it to CPT as well, that interpretation of the law. So we've received some denials, RFEs, when people have changed from one master's to another master's and immediately taken CPT. So that's something that students should be aware of and be wary of before you decide to take CPT. So that's one thing with CPT. Now, another status question that we get for the students is, oftentimes, especially when they're on CPT, they're studying in a different state and they're living in a different state because they're working in a different state. So they send extensive RFEs asking how you can possibly work in one state and study in another state. Right. And they are questioning this because they want to make sure that you're not doing online classes, because you can only take 2 online courses per semester. And so they want to make sure they're not violating it, because if you are taking more than the courses allowed, online courses allowed, then you're violating your status. So then we often show documentation because then the way these universities have classes, they usually have them on weekends or Friday, Saturday, Sunday. That's how they have, they've organized their curriculum. So we show that, they fly on the weekend or they drive. So you have to show flight tickets, hotel bookings, parking, to show that you've actually gone to class. And of course, attendance records from the university, assignments that you've submitted in person. So there's a whole list, sometimes it goes to hundreds of pages, documentation that we have to show. Maybe expenses that you incurred at the university, maybe you went to the cafeteria, you bought something, just to show that, it's an in-person class and you didn't take it online. So that's the other kind of RFE, that we get for students. So I think these are the main RFEs you get for students. Now, maintenance of status can be for any status. It could be if you're on a B2 and you want to maintain maintenance of status. RFE would be pretty much your I-94. They want to make sure that you were on your I-94 and it hasn't expired. So you have to submit an I-94. So if you don't, they'll send you an RFE asking for proof of maintenance of status. Or, for example, if they find out that you have worked illegally, because you can't work on a visitor's visa, maybe you worked on a gas station or somewhere and they came to know, then that's a maintenance of status RFE. They'll say, it came to a notice that you worked at so-and-so gas station, show us that our information is wrong. In the same way, suppose you file a H1 extension, then your maintenance of status is, it's not enough just to have an I-94, which is valid, though that is required. But they'll ask for proof that you actually worked. So there are 2 elements to maintaining a status in the H1. You have to show that you are on the payroll and you have to show that you have a valid I-94. So in order to show that you're on the payroll, you have to show pay stubs. And if you don't have pay stubs for some reason, you have to give proof of why you don't have it. For example, if you were on unpaid vacation, which you took, the employer didn't force you to take, but you took it on your own because you had medical reasons, family reasons, then they will ask for a letter from you to the employer requesting that leave and proof that the employer has granted the leave. If you're not getting paid the prevailing wage, sometimes maybe you're on the payroll, but your W-2 is lower than the prevailing wage. Even then, you're not maintaining your status. So you have to show proof of what happened. Did you take leave? That's why your W-2 doesn't show. Then you have to show all the pay stubs the entire year. And if you have some excuse for not doing that, which is accepted by the law, then you have to document it. For example, you stopped working for 3 months, or you went to India and you didn't have to be on the payroll, right? You can document it that way. Or you can show that you filed an amended petition for decrease in the hours. Maybe your job changed from a full-time to a part-time. Okay. So as long as you did what you needed to do with USCIS and you got USCIS's approval, or at least you filed a petition for the amendment, you can show that receipt that you filed it. So maintenance of status, depending on which status you're on, they can ask for different kinds of documents.
Okay. So we have other caller, Raju from Bangalore. Hi, Raju.
Yeah, madam, sorry, my line got dropped. I don't know whether I was disconnected or I was two things I missed out on that. So one is, of course, I wanted to thank you, but more importantly, actually, this is for my son. He's already got his. I told you, right? He's got interview for his business visa. Just a quick question from him. We have been waiting all night here in Bangalore because it's too early now. Uh, if he comes on a business visa, and is it legally possible for him to parallelly apply for a student visa while he's there in the US without coming back to the country?
So yes, it's possible, but they're always going to look at it suspiciously in the sense that you have to make sure that he had no intent of being a student before he entered into the country, because he's basically entering saying that this is what I want to do. So there shouldn't be
Right.
If there's an intent issue, and if they find out that he had this intent of moving to an F1 even before, they'll say, then you should have just come on an F1 and not given the wrong reason for entering. So they might find that
Right.
entry to be illegal. So in order to avoid that issue,
Right.
then it's better to wait for maybe 60 days or 90 days before you file for a change of
Because of
status
this
from a B2 to an
COVID, we
F1.
lost about 6 months of all this education planning and all here in India because the embassies were not there. So his employer has applied for a business visa as part of the job and he wants to continue his education. So just thinking, ma'am, do you have a representative or office here in South India or at least in Bangalore with whom we can meet up and maybe seek some advice? Would that be possible?
We have an office in Hyderabad, not in Bangalore. You could email me and I can send you the details.
Oh, sure. I will do that, ma'am. I just wanted to thank you earlier. It got disconnected, so thank you for your information.
You're welcome.
Thank you, Raju, for calling back. We have other caller, Krishna from Chicago. Hi, Krishna.
Hi. Good evening, madam. Thank you for the opportunity. I have one quick question. My wife visa, actually H4 visa, is valid up to March 25th, ma'am. If she wants to plan I don't know whether is there any grace period to stay one more 10 days to go India, or before 25th she should leave the country?
So why don't you file an extension?
Because one thing is, like, if I file a extension now, she wants to needs to go in the month of May, madam. In these 2 months, the decision won't come, right? That is
yes, it won't come, but anyway, you can file anyway. It doesn't matter that it won't come. Just keep her in status. But there is a 10-day grace period for the I-94, but sometimes that is included in the I-94 itself. So you have to make sure that you're not adding an additional 10 days to what has already been added, right? So look at the H4 I-797 at the bottom. The top will not have the 10 days grace, but the bottom I-94 attached to the I-797 will usually have a 10 days grace. But if you have the I-94, which is online, which is from the port of entry, then they will not usually have that 10-day grace. So you can add 10 days to it. But make sure you're not confused as to when that 10 days ends.
Okay. Otherwise, you said that other way, like, we can apply extension here and she can, without decision comes, if she travels to India, is the visa getting the need to go for stamping again in the consulate in the Hyderabad?
Yes, because the thing is, if she doesn't have a visa, how is she going to come back? And the visa would have expired, right? So the filing here becomes null and void. When she leaves, it becomes null and void because she has to be in the country for it. She has to at least come back into the country. So how will she come back without a visa? So, and anyway, for a H4, you don't need to have a 797 filed initially. So you can just come back, go to the consulate directly, get a visa and come back in.
Oh, okay. So that is the best way. Before applying only, she needs to travel. That is the best way, right, madam?
Right. So instead of saying that additional time, she should leave earlier if she plans to leave anyway. Or she needs to file for an extension.
Oh, okay.
Thank you, Krishna. So again, back to our question. So what are the list of documents to be submitted for RFP response for maintenance of status for F1 cap gap?
Oh, cap. So basically, the F1, specifically cap gap, just to rate for those audience, people who don't know, is when you file a change of status from F1 to H1, it might be that because the new H1 as per the cap doesn't start until October 1st, right? You're filing 6 months in advance. So in the interim, it's possible that your F1 status might expire. Either your OPT is expiring, or maybe your school is getting over, whatever it might be. In order to accommodate such people, the USCIS has come up with a cap gap rule. And as per the cap gap rule, whatever your status was as of the date of filing, as long as you were in status as of the date of filing, USCIS automatically extends that status until October 1st. So that's what the H-1B cap rule is. And in order to make use of that H-1B cap rule, the only thing you need to do is submit a copy of your H-1 petition which you filed, or a copy of the receipt to your DSO. So that's the requirement for the H-1B cap. So suppose you're on OPT, and even if your OPT expires during that time, you can still continue to work because your OPT has been artificially extended as per the H-1B cap. If you did not have OPT at the time of filing, then if you get it later, and if it expires, then you cannot work, obviously. So whatever your status was as of the date of filing, that will be your status. Okay. So sometimes they send RFEs. I don't know when they send RFEs really for a cap situation. They might send an RFE saying, prove that you're in status. And if you're working and you continue to work, then they might say that prove that you contacted the DSO or something like that. But usually cap RFEs are rare. You don't usually get an RFE saying prove that you've been approved for a cap because there's an automatic approval. Okay. As long as you inform the DSO. And that's been included in the service.
So also right to control RFEs, are we still getting those? Yeah, I think we touch based on this a little bit.
So right to control RFEs are not happening anymore, except if there was a mistake. So again, we touched base on this. There was a litigation, as I was saying, and the Trump administration was trying to use that right to control law to pretty much deny 50% of the RFEs was really right to control. And the denials were based on right to control. Not so much specialty occupation, but more right to control. So that was taken away from USCIS, and that's why now we have less RFEs and less denials. And also they were they were approving cases for 1 day, 2 days, 1 month, based on this right to control law. So the right to control law basically said that you have to prove, if the person is not working at your office, but is working at a client site, the petitioner is obligated to prove that they have the right to control the day-to-day activities of the employee, and that they are the actual employers. And just being on the payroll is not enough to show that they are employers. They have to show the right to supervise on a day-to-day basis. Also, the right to control rule said that you have to show that that right to control existed for whatever period you're asking the H1 for. If it's 3 years, then 3 years. So that led to a flood of RFEs asking for right to control documentation. So they wanted it they wanted it not just in the form of a statement from the employer or petitioner saying that yes, we have the day-to-day control of the activities. They wanted it from the client, from the horse's mouth, from the client. So we had to get detailed in-client letters saying that, the person has the employer has the right to control and not us. The employer has the right to hire and fire, not us. The employer has control of the general duties of the beneficiary. The employer has the right to reassign the beneficiary to a different project. We don't have that right. So all these, this language had to be listed in the end client letter. And sometimes the clients would refuse to give all that language because they wouldn't understand the importance of it, or they just said that we don't know who has that right. We don't have it, but we don't know if the employer has it or not. How do we know? So they would just refuse to give it because they would be afraid of, saying something that was incorrect, maybe not having enough information. So when they didn't get such a letter from the end client, then we had to produce other documentation to show that, in fact, the employer had the right to control. And that was in the form of an employment contract where those terms and conditions were enumerated, were specifically there saying that, oh, we are going to be controlling your duties, everything had to be spelled out in the employment contract. Right. And that we have the right to give you the bonus, we have the right to control your salary, etc., etc. All those terms and conditions had to be written in the employment contract. And also, we had to actually show documents like the review documents, so the documents going back and forth between the employer and the employee saying that they have reviewed the work. Based on the review, they have done salary increases, or, so reviews going back and forth every 2 weeks. So that documentation will be submitted. And then to show that this is happening for a period of 3 years, they would ask for purchase orders or letters from the client saying that the project will last for 3 years. If any of these things were not there, they were denying the cases. And it's very difficult to get this kind of documentation that I'm just talking about. So a lot of cases were getting denied. Right. Then we had, there was litigation. ITServe filed a case and they won. And the judge basically said that it's ridiculous. Why do you need to? What is this artificial definition you're giving of employer and employee? Where did you get this definition from? The common law definition is if you are hiring, firing, and if you're paying, then you are the employer. So nothing else is needed. So everything went out of the window. And now we are not seeing, neither are we seeing short. And they also said you cannot give short 1 day, 2 day H1 approvals. You have to give the H1B approval for the entire 3 years. If you're not giving the H1 approval for 3 years, you have to give reasoning behind why you're not giving it. So, so that is now we are seeing 3-year approvals, and we are not seeing RFEs for right to control anymore. But the USCIS tried to reintroduce this whole concept recently through the DOL, as I was talking about. The DOL issued a memorandum saying that if you do not have the right to control, basically then the end client also has to file the LCA and H1. So this would end the consulting company business completely because no end client will be willing to file a H1. If they are willing to, then they'll just hire them directly. Exactly. Why will they go through the pain of, you doing the H1 and all that? The whole consulting company process works this way. So if that is not there, then it will not work. So they tried to do that, but luckily the Trump administration did not have enough time to publish that regulation. They didn't do it on time. They didn't do it by the 20th. So the regulation was automatically rescinded by the Biden administration because they said that if it is not published, then it has to be rescinded. And the DOL memo that talked about this also had to be withdrawn, the press release, because there was no regulation. So there's no basis for the DOL thing as well. So that's what happened with right to control. So they keep trying to introduce it and keeps going away, and then they try new ways of introducing it. But I'm hoping now with the Biden administration coming in, I'm hoping that they won't go after consulting companies in this way.
Sure. And the last question, what is a golden immigration message to our viewers?
I guess what we need to do is we need to document. So we need to document our cases properly.
Sure.
We need to make sure that USCIS does not have an excuse to deny, right? So I think providing upfront complete packages with all the documentary evidence is important. That's one thing. Second, we've learned from this present administration that the only way to get the rights that are ours, and the only way to make sure that we get our immigration benefits is to litigate. Don't be afraid to litigate in federal court, because otherwise USCIS will not listen to us. So we've learned that lesson, and there's been so much immigration-based related litigation, and 90% of the litigation has been in favor of against USCIS.
Sure.
So all the decisions have come out against USCIS. So don't be afraid to litigate. For example, H4 EADs, H1B wrongfully denied cases, litigate. And what is happening is that USCIS is withdrawing, is not even waiting for the decision from the judge, but is approving cases. Okay. Because they know they're already in the wrong.
Sure. Yeah, I think we can talk more about this in our next episode. Thank you, Prashanthi Reddy, for joining us today and answering the questions on the H1B and RFEs. And that's the end of the show. Please do follow us every Wednesday on the same time. This is Kalpana signing off.